President Trump fighting subpoenas, basically every one of them. He's trying to stop former White House officials from even testifying. Could that lead to more legal exposure for the president? A former federal prosecutor will join us to weigh in. Then, the Supreme Court working on a case about the census and how the justices' rule could determine outcomes of future elections. Also, our legal panel will join us to take a look at a bunch of cases in the news, including new developments in the high-profile stories including Harvey Weinstein, Robert Kraft, and Jussie Smollett. Evening, everyone, and welcome to RFL. I'm Richard French. Well, President Trump, he's continuing to fight a slew of subpoenas. The president filed a lawsuit against House Oversight Committee Chairman Elijah Cummings as he tries to block that panel from obtaining his financial records. President Trump also fighting the subpoena that's calling for former White House counsel Don McGahn to testify before the House Judiciary Committee. The president, he was asked about that today. Here's what he said.
The subpoena is ridiculous. I have been the most transparent president and administration in the history of our country by far. We're fighting all the subpoenas.
A lot of that not true, but anyway, the president was not nearly finished. Here he is once again.
Now we're finished with it, and I thought after 2 years we'd be finished with it. No, now the House goes and starts subpoenaing. They want to know every deal I've ever done. Now Mueller, I assume, for $35 million, checked my taxes, checked my financials, which are great, by the way. You know they're great.
We don't know they're great, but anyway, this next piece of news, I'm pretty sure is going to make the president even angrier. Deutsche Bank, they've agreed to turn over some of Trump's financial records to the Attorney General of the state of New York. CNN reporting that those loan documents, they're related to Trump International Hotel in Washington, golf courses, as well as Trump's unsuccessful efforts to buy the Buffalo Bills several years ago. Well, joining us now is former federal prosecutor Carol Lamb. Carol, good talking to you again.
Thank you. Good to be here.
Well, let's first start off with the late developments today with Deutsche Bank. Tell the folks at home why the president may be concerned that Deutsche Bank is cooperating with some of the financial requests.
Well, here's why the president might be concerned, because although it's, I think, quite likely that federal prosecutors have already gotten those documents from Deutsche Bank, of course, all federal prosecutors roll up to this Attorney General Bill Barr, who we have in that position right now. However, New York State prosecutors in the New York State Attorney General's office do not roll up through the Department of Justice, and they therefore are not subject to the Department of Justice's policy that you can't indict a sitting president. So we don't know what the Attorney General in New York will do if improprieties are found by the president himself with respect to taxes or other financial dealings in New York State. But that would be the president's concern, that the New York State Attorney General is not subject to the rule or the policy that you can't indict a sitting president.
Now, I know we don't know the answer to my next question, but as an educated guess, there was no reference in Mueller's report to any of Trump's tax returns. Do you believe he had access to them? Do you believe he went through the returns of Trump?
There's no question that the special counsel, in my mind, there's no question that the special counsel had access to and went through the president's tax returns. That is a fundamental starting place for any white-collar fraud prosecutor. You look at money, and therefore you get tax returns. And you know, there have been 12 referrals that we don't know the subject matter of. 12 referrals from the special counsel's office to other prosecutors' offices throughout the Department of Justice. So one of them or more of them could clearly be a tax investigation.
Mr. McGahn has a date for which Congress would like to see him appear and testify under oath. Obviously, the president is doing everything he can to prevent that. That said, what do you think the likelihood is that we do hear from Mr. McGahn, and what do you think Congress possibly could learn beyond confirming what we learned in the report that McGahn basically saved the president from his worst instincts?
Well, I think that the odds are very good that we're going to hear something from Don McGahn or just have a knockdown, drag-out fight about it, because the president has essentially waived already his right to assert executive privilege over subject matter that Don McGahn can talk about, because in the Mueller investigation, he instructed Don McGahn to sit and talk to the special counsel. And so any subject matter that Don McGahn has already talked about with the permission of the president, any claim of executive privilege has been waived, meaning that the president cannot now come in after the fact and say, well, now I don't want you to talk about that same subject matter. He's already waived that privilege. Other subject matter, if there is other subject matter that the House wants to look into, that's a different story. Sometimes it comes down to a question by question assertion of privilege and then a fight over it. It can be very slow and tedious. But with respect to what he's already told the special counsel, I don't think there's any privilege left to assert over that.
Obviously, there's always spinning after reports come out, but we learned even more developments relating to the Russia spying, and a disturbing one from the Times is reporting that the Homeland Security Secretary was strongly discouraged from even bringing up the issue, even though it's an ongoing threat, Russian hacking, because the president didn't want to hear anything about it. But we also heard from Jared Kushner's characterization of what Russia did. I want to play it for our audience, and then I want to get your reaction.
You look at what Russia did, buying some Facebook ads to try to sow dissent and do it, and it's a terrible thing. But I think the investigations and all of the speculation that's happened for the last 2 years has had a much harsher impact on our democracy than a couple of Facebook ads.
Carol, can you just please put to rest this idea that it was just a couple of Facebook ads? For the folks who haven't gone through the 400 pages plus of the Mueller report, it was anything but.
No, it was that's a terrible mischaracterization of the Russian government's attempts to influence our electoral processes. The estimates are that their manipulation of Facebook reached 120 million people. There were clear, targeted attacks on the entirety of our electoral processes. I think one of the most stunning things that we learned from the Mueller report was that the Russian intrusions reached into the state and local registrar's offices, the voters' registrar's offices. And when they have that level of deep intrusion into our voting processes, that's clearly more than purchasing a couple of Facebook pages.
Even to a casual observer, there seems to be a running theme that regardless of the request or even the subpoenas, the president refuses to cooperate. In figuring out a remedy, is it that we had a blind spot that we never expected that a commander-in-chief would just be so oppositional to rule of law? Or is it that legislators are in a bind because they don't want to have the stomach to pursue contempt potentially? Talk about the idea about a president just saying, no, I'm not gonna cooperate, and what remedies exist if this continues.
Under constitutional law, there are a lot of different views about how to interpret the Constitution with respect to a president's exposure to the criminal laws. Yes, he is the president. He has a lot of responsibility on his shoulders to bear, and he can't have to go around addressing a lot of criminal investigations. That is a huge distraction. But it could be that we have cut or we've drawn the line maybe in the wrong place all these years. And the contempt powers that Congress has, we do have separations of powers, but when you get into the stratosphere, it gets a little bit murky. There are three ways that Congress can hold a witness in contempt: for refusing to testify or for refusing to produce documents. But in two of those three methodologies, they have to go to the Department of Justice to seek enforcement of a contempt action. And so when the witness comes from the executive branch, which is both the president and the Department of Justice, in the past, on the few instances where contempt has been found for an executive branch employee, the Department of Justice has simply said, we disagree with your conclusion and we are not going to help enforce that contempt order. The third method that Congress has to try to enforce a contempt order, which is putting in jail somebody who has refused to cooperate under the inherent powers that Congress has, that's limited by the length of the congressional term. And after all the objections and all the arguments and all the appeals to the court, it's quite likely that the person may not end up actually going to jail at all. So there aren't any really great solutions when the witness that you're trying to hold in contempt is an executive branch witness. And that's why at the end of the day, usually there's some sort of compromise struck. The courts have said in the past, don't make me make a decision here. You guys try to work it out. So usually a compromise is struck, and it's usually a compromise in which neither party is particularly happy.
And that seems to be the general theme right now. Not too many folks happy. Carol, I appreciate the time as always. Thank you so much. All right, everybody, when we come back, the Supreme Court, they've got a couple very important cases on their docket. Now, they're going to take a look as to whether or not it's legal for companies to discriminate against workers due strictly to their sexual orientation. You'd think this would be settled law, but it isn't. Washington Post Supreme Court reporter, he'll join me after this break to explain.